This podcast is brought to you by the School of Advanced Study, University of London.
Okay, well, a very good evening to everybody. For those of you who don't know me, I'm David Cantor. I'm Director of the Refugee Law Initiative here at the School of Advanced Study. And it's really my privilege and pleasure to welcome you this evening to this seminar on the voting rights of refugees with Dr. Ruvi Ziegler, who's sitting here with me. This is our first Refugee Law Initiative event of 2015, and therefore it's, I think, slightly special, but it's part of a wider programme of events that we've got coming up in the next couple of months. Some very, very interesting stuff. Next month, on the 10th of February, we've got Martin Jones coming down from York to talk to us about developing a law of asylum in Asia as part of this same refugee law seminar series. On the 19th of February, we have a workshop which is open to practitioners and scholars alike, looking at new approaches to dealing with climate change cross-border refugees. And that's work that Tamara Wood from Australia and myself have been doing, respectively, in Africa and Latin America. And lastly, next month, we've got a book launch of a book that both Ruvi and I contributed to on how international humanitarian law, the laws of war, apply to refugees and what they have to say about the protection of refugees. That will take place at Chatham House rather than here. So you're very, very welcome to come to any of those events, but please do register in advance. Tonight's seminar on the voting rights of refugees touches on an issue that reaches right to the heart of what being a refugee is all about. It's about how political relationships are constructed. And here, in contrast to much of refugee law, which looks at the rupturing of political relationships between a refugee and their country of nationality or country of origin, Ruvi is going to be talking to us about a rather different situation, and that's the possibility of building up a political relationship between a refugee and their state of asylum. There's very, very little work being done on this, and I'm really thrilled to have Ruvi here to talk to us about it. He's really a leading expert on this, having written his PhD at Oxford on the subject of voting rights of refugees. In introducing Ruvi a little bit, I'll refer you, of course, to the programme online, but Ruvi is an expert on many different areas of human rights law, international humanitarian law, and of course refugee law. And it's a distinct pleasure to have him here. He's one of our community of scholars who together, I think, have really been with the Refugee Law Initiative since the start and helped to develop some of the interests and programmes that we've been able to look at over the last 5 years. So I'm going to invite Ruvi to speak for the next 40 to 45 minutes. It's very much up to him whether he's inviting questions during the presentation, but you'll certainly have the chance to ask questions and to discuss any of the points raised in about half an hour after his presentation is finished. I should mention that the event's being filmed and will be a podcast, so for those of you who wish to ask questions but don't wish to be identified, then you're welcome to ask your questions anonymously. So do bear that in mind. Without more ado, I hand over.
Does he need to change?
Well, why don't you stand and I'll adjust it? How about that?
Okay, yeah. Sorry, I have a bizarre tendency to like to stand. Yeah, okay, perfect. Well, thank you very much, David, for this really, really kind introduction. And thanks everyone for coming. Not only will I stand, but I'll move a little bit so I won't block the unnecessary parts of the slide. Okay. So as David said, this is work that I've done a couple of years ago, but is still very much in the process of thinking about trajectories that follow from this, and relates to the question of the status of a person in their country of asylum after they've been recognized as a refugee under the 1951 Convention relating to the status of refugees. And so the starting point for the entire analysis that I'm going to embark on is that a person has arrived at a country that is a signatory to the Refugee Convention. His or her application has been assessed, and they've been recognized by that country as entitled to refugee status. And so the assumption being here is that that country respects in all other respects, the provisions of the Convention as they apply to that individual. And the argument I want to proceed with is an argument as, in legal terms, de lege ferenda. It's an argument that tries to push the boundaries of current law forward, tries to do what the International Law Commission calls progressive realization of the law, because it's not an argument that suggests that refugee law as it currently stands requires states of asylum, once they've recognized somebody as a refugee, to grant them refugee status, but rather that it is desirable that they do so. And it is desirable that they do so precisely because of that point David made in the introduction, because there is a certain need for an establishment of a political relationship between the recognized refugee and her state of asylum that comes, as you were, in lieu of, or in place of the severed political relations that that person has with their state of origin from which they've fled and to which they're unable or unwilling to return. So there are really two substantive claims that are interrelated that I'm putting forward here. The first one is that recognized Geneva Convention refugees are a special category of non-citizen residents. The reasons they're a special category is because unlike other non-citizen residents who do have a different state of origin that is their state of citizenship, with which they do retain a degree of political relationship, they are needed for what I call full membership in a political community. And the key point here, and I'll explain why this is in brackets and I'll explain why this is indeterminate, is that the need that they have for that membership in a political community is for an indeterminate period of time. And that very much attaches to the heart, conceptually, of what it means to be recognized as a refugee under the Refugee Convention. Namely, the idea that this is recognition that is done for a period of time that neither the refugee nor her state of asylum know the length of when recognition happens. And so it is desirable, I argue, that they be treated by their countries of asylum as if they were their nationals through what I call, and this is, excuse the rather convoluted legal language here, which I'll explain, through temporary disaggregation of rights that are otherwise accepted as citizenship dependent in international law. And what I mean by this is that even if their states of asylum otherwise restrict voting rights in their elections to their own citizens, here they should treat refugees differently than they treat other groups of non-citizens. Hence the idea that refugees are a special category of non-citizen residents. Now some countries, for instance New Zealand, allows all permanent residents to vote in all types of elections. And so there, the state has generally decided to disaggregate the right to full political participation from citizenship and to attach it to residence, albeit permanent. But the vast majority of states in the world haven't. Certainly for national elections and even for other forms of elections, local and otherwise. My argument extends throughout all forms of elections that are coming courts. And so the argument as such, and I'll get to that towards the end of the presentation, the argument as such accepts as a starting point the idea that states have often good reasons to limit participation in their political processes to full members of their political community. That is, I'm not making an argument of a general nature about that, this form of disaggregation of political rights from political membership. But I am making an argument that says the type of claims that non-citizens make towards their state of residence that justify that disaggregation are the types of claims are stronger when it comes to recognize refugees, and they're stronger because of their very unique political predicament. So this will all become, hopefully, clear as I go along. So I'm not going to go into great detail looking at the refugee definition, and certainly not when it comes to the FAIR 3 condition. Each one of the words in the definition of a refugee under Article 1A2 has had a degree of writing on it that I'll probably not accomplish in a lifetime. So we won't go into that, and there's a very good reason for me why I don't go there, and that is, as you'll recall, the assumption being that recognition has already happened. So the state has recognized, regardless of how it interprets, you know, the extent to which particular social group should extend to certain groups, etc., it recognizes that that person is entitled to refugee status. The one condition, and these are of course cumulative under the definition, the one condition I do want to spend a couple of seconds on is the idea that the person must be unable or unwilling to avail themselves of the protection of their own country. Now this has historically been considered to be a condition that refers to the external protection, that is the protection that states grant their nationals abroad, diplomatic protection and consular assistance. Now as you'll see as I proceed, this is a point that I go into, and in suggesting that refugees are now increasingly recognized as a group that needs some form of an amelioration for their condition that is entailed by the fact that they cannot enjoy the protection of their own country when they're abroad. So this used to be the only way in which the word protection in this definition was interpreted. But as human rights law has interacted with refugee law, the notion of protection under the Refugee Convention has taken on an additional life, as it were, or an additional hat. And that's the idea that it is the notion that states owe protection duties to their own citizens and to persons who live in their territory under their jurisdiction. And so the idea that being granted refugee status is a recognition by a state of asylum that the refugee state of origin has failed to provide her with the form of protection that she deserves, right? Be it through direct persecution by the state, or be it through persecution by non-state actors that that state tolerates. That recognition, I suggest, is important if we understand the notion of protection when it comes to its contours in the relations between the individual and her state of asylum. And so I invite you to think about protection in those terms. Now, I want to talk about what it means to be recognized as a refugee in terms of the security of residence that refugees enjoy in their state of asylum. Now, I define this as conditional security of residence, and the reason for this is the following. Under international law, permanent security of residence is granted to citizens of states. That is, if you're a citizen of a state, then that state is required to let you return to that state and reside there permanently. If you're not a citizen of that state retains a degree of prerogative that changes to the extent that you have established relations that then bring about human rights obligations that state imposes vis-a-vis you as somebody who's resided there for a certain period of time. But that commitment is not unconditional. And so what I want to suggest is that if refugees were to be naturalized, that is, if they were to become citizens of their state of asylum, then they would enjoy in that state permanent security of residence. And indeed, if that were to happen, then as Article 1C3 of the Refugee Convention says, and I'll talk in a few minutes about all of the cessation clauses of the Refugee Convention, as Article 1C3 does, it indicates that if someone were to become a citizen of another state, that is, enjoy a status that is a full and permanent status of full political membership in an alternative political community to their original one, which was their state of origin, then the refugee status shall cease. And so if the state of asylum were to grant refugees citizenship, then there would no longer be refugees under the Refugee Convention. And of course, they would enjoy whatever other rights citizens enjoy in that state. And the assumption, as we'll see in a few minutes, is that citizens do have, under internationally recognized treaties, a right to participation in electoral processes of their state of citizenship. Now the catch is that neither refugee law nor international human rights law rather require countries of asylum to naturalize recognized refugees, no matter how long they've been there. Now there may be an argument of a general nature in human rights law about residents being at some point granted or having at some point to be granted an access to naturalization processes that are properly available. And we'll see that with refugees there is a soft obligation in the Refugee Convention to facilitate these processes if they exist. But there is no hard obligation on status of asylum to naturalize. And the reason for this is that refugee status is considered to be potentially temporary, which is why I referred to at the start to the notion of this being an indeterminate period of time. In other words, it may be that the circumstances that have led to that person being granted refugee status, be it individual circumstances, and we'll see in the cessation clause some reference to that, be it general circumstances that relate to the nature of the situation in their state for which they have left. There may be circumstances where persons can indeed have their status revoked and be returned to their states of origin. And it even is the case that under UNHCR's guidance, repatriation remains the preferred solution for refugees. And so it's perhaps not a coincidence that the Refugee Convention doesn't require states to naturalize, because it recognizes that refugee status may remain a temporary one. Now, I said at the beginning of this slide that refugees being recognized have conditional security of residence, and I suggested it is a stronger form of security of residence than the form of security of residence that a regular resident enjoys. And the reason for this is Article 32 of the Refugee Convention, which, unlike Article 33, which applies whenever a person comes into contact with a state, whenever a person is under its jurisdiction, which may be before they're recognized as refugees. It may happen, when they're interdicted at sea, as we too often know, by a ship of a state. That obligation, the non refoulement obligation under Article 33, is an obligation not to return a person to a place where, to the frontiers of territories where their life or liberty would be a risk because of one of the Refugee Convention grounds. The obligation in Article 32, which accrues when somebody is in the territory lawfully and somebody recognized as a refugee clearly is in that status, is a much stronger obligation of non-expulsion. And it's an obligation that contracting states shall not expel refugees lawfully in their territory, save on grounds of national security and public order, and that applies to expulsion to any state. Now the rationale for this ought to be fairly obvious. The only place which is obliged to accept a recognized refugee is her state of asylum. Is her state of origin. That is a state, of course, that the state of asylum is not authorized to return that person to, being sort of a built-in follow-up to the idea that they recognize that person as a refugee, meaning that they recognize that all the refugee conditions apply to that person. And so all other countries in the world have no obligation to accept a refugee into their territories. And so there should be no reason for the state of asylum to try and expel them. And so if we combine all of these conditions, right, the idea that refugees once recognized are non-deportable, and that their status may be held for an indeterminate period of time, and that the states are not required to naturalize them, and following from that to grant them the various forms of political rights that they normally grant their citizens, we see that there is an indeterminate length of stay in that particular status, namely as a recognized 1951 Convention refugee. And the argument I make is that except for Article 1C3, which is the one that is under the control, or the circumstances that give rise to it, are under the control potentially of the country of asylum. That is, the country of asylum can decide to naturalize and then end refugee status. All of the other cessation clauses in Article 1C, which is an exhaustive list, namely, you have to fall into one of these cessation clauses in order to seize refugee status, otherwise refugee status is retained. All of these other conditions depend on things that are beyond the control of the state of asylum. So the first two relate to a change in the political nature of the relations between the individual and her state of origin, namely reavailment of protection of that state or reacquisition of nationality if they've lost it of that state. The fourth condition is of that person having voluntarily returned to their state of origin. In that case, by definition, one of the conditions under Article 1A2 no longer exists because they're not outside their state of origin. And 5 and 6 relate to fundamental changes in the circumstances of the country of origin, but these cannot be predicted in advance. We don't know if we recognize today somebody from Eritrea as a refugee, if there will be a regime change that would allow people to be returned to Eritrea. We couldn't know in 2003 when we recognized somebody from Sudan as a refugee that there will be a political change that will lead to a split up of Sudan to the Republic of Sudan and the Republic of South Sudan, and that potentially you could then return individuals to South Sudan. These are things that cannot be predicted in advance by the state of asylum when it makes that formal recognition of a person as a refugee. And so that's the picture that emerges as the Refugee Convention presents it. Now, recognized refugees are entitled to the full scope of protection both under the Refugee Convention and under other international treaties, and I've chosen the International Covenant on Civil and Political Rights simply because of the relevant treaties that relate to political rights. It's the most widely ratified, it's the most internationally recognized, and all the states that have signed the Refugee Convention have also signed the ICCPR. And the Refugee Convention predicted that there may be rights that accrue to refugees beyond the Refugee Convention, and so said that nothing in the Convention shall be deemed to impair any rights and benefits granted by a contracting state to refugees apart from the Convention. And indeed, Article 2 of the ICCPR said generally that state parties undertake to respect and ensure to all individuals, not to all citizens or all residents, but all individuals, the rights under the Convention. And so that presumably applies to the whole host of rights under the International Covenant on Civil and Political Rights, except, of course, there is that catch. And the catch is that in Article 25 of the International Covenant on Civil and Political Rights, unlike all of the other rights under that convention, the rights makes an explicit reference to the rights of every citizen to vote and to be elected in genuine periodic election, which will be by universal and equal suffrage. And so the International Human Rights Treaty regime generally grants refugees a set of rights under both refugee law and under human rights law, but clearly doesn't make a reference in the Refugee Convention to voting rights, and under the ICCPR, even though states are entitled to extend voting rights to non-citizens, there's nothing in that convention that prohibits it, there's also no obligation as such. And this is why I say my framework is one of desirability, rather than one of suggesting that this is a requirement of international human rights law as it stands today. And that desirability is based on the following. I suggest 3 elements of political predicament that make refugees, as it were, qualitatively different than other groups of non-citizens. Now I should say, and sort of preempt the question that will still come, but I'll preempt it nonetheless. This is not a binary. That is, I'm not suggesting that the kind of arguments that I'm about to make that suggest that refugees have unique political predicament suggests that no other group of forced migrants or others are on a spectrum fairly close to refugees. The argument I make is that refugees are the recognized refugees under the 51 Convention are the most clear and distinct example of a group that suffers from that degree of political predicament. And so one can draw then by analogy some of these arguments that apply to some other groups. But none of them, I suggest, apply to the same degree of force. So the first argument is one about the right to return to the state of origin. As I said, that is a right that under international law is recognized for every person in relation to their own country. That's what we see in the ICCPR and in various other international treaties, that no one should be arbitrarily deprived of the right to enter his own country. Now this is of course a right that is by definition not realizable when it comes to recognized refugees. Even if they theoretically could return to that state, they would not want to. So they may be either unable or unwilling to return. That is a constitutive condition of their being recognized as refugees, so long as they hold that status. Now what does international refugee law do already, I suggest, to some extent recognize that particular predicament and rectify it? What it does is it requires contracting states to the convention to issue recognized refugees with a convention travel document that says, that's written in Article 28 of the convention. It says that contracting states shall issue to refugees lawfully staying in their territories travel documents for the purposes of travel outside their territory, unless compelling reasons of national security or public order otherwise required. Now why is that important? That is important because these travel documents are to be used by refugees instead of their original passport from the state of origin if they still possess ones. Because this is meant to be like their passport. And like a passport, the schedule to the convention says that each contracting state undertakes that the holder of that travel document issued by it, in accordance with that article, shall be readmitted to the territory at any time during the period of its validity. So what have contracting states done here? They've effectively said, for the purposes of travel outside the state of asylum, we consider refugees to be like our nationals. We don't issue travel documents to other residents because they have travel documents of their states of origin. Here there's a group that cannot use the travel documents of its states of origin, so we shall issue them documents so they can travel elsewhere once recognized as refugees. And we guarantee said states that if they wanted, for instance, to expel that refugee, we will readmit that person back, the same way we would have admitted our own nationals. And so that is a unique political predicament of refugees that is rectified already, I suggest, in a refugee convention. Now, related to the idea of travel abroad is that notion of diplomatic protection and consular assistance abroad. Now, on that, there is a very interesting development in international law. And that is that historically, this has been considered to be a right that the state has vis-a-vis other states, but not a right that the individual has vis-a-vis her state. In other words, it was considered to be an interstate relations issue alone. But that is, I suggest, changing. Hasn't changed to the extent that we can say there is now an obligation on all states to provide diplomatic protections to their citizens that have a corollary right of individuals to demand that form of protection. But this is the trajectory which I identify in an article that I'll mention in a minute. The most clearly delineated sort of form of that obligation actually appears in the Convention on the Rights of Migrant Workers and Members of Their Families from 1990, which is a fairly recent treaty. It came into effect in the mid-2000s. Unfortunately, not very widely ratified. But what that convention says in relation to migrant workers, which are, unlike refugees, individuals who have not severed their ties with their state of origin, namely, there are individuals who are outside their state of origin, but have done so, have left that state voluntarily and retain a realizable right to return to that state. With regard to migrant workers, there is a statement, a very clear one, in the Convention saying that migrant workers and members of their families shall have the right to have recourse to the protection and assistance of the consular or diplomatic authorities of their state of origin, namely retaining that political relations which comes into effect also in the international arena. And there's a series of judgments in recent years from some common law jurisdictions, like this country in the Abbasi case relating to Guantanamo Bay, which referred to the recourse to diplomatic protection being a quote-unquote normal expectation of a citizen, or the South African Constitutional Court in Kaunda, which says that a citizen's request has to be considered and responded to appropriately. And indeed also the Treaty on the Functioning of the European Union, which whilst not saying that member states are obliged to give diplomatic protection to their own citizens, said on the basis of the principle of non-discrimination that if they do provide that form of protection to their own citizens, they should extend it to citizens of other member states if that other member state has no consulate in the respective state in which assistance is sought. Now this is, I suggest, even though there's not as such a right of EU citizens to diplomatic protection, certainly a recognition of the very importance of having recourse to diplomatic protection. And was actually one that was being used quite extensively by EU citizens in various contexts, including the earthquake in Haiti, where there were no embassies of all states, or the civil war in Libya, the tsunami in Japan, and other instances where some EU states have assisted other EU states in their recourse to diplomatic protection. And so where do refugees come into this issue? There is as I said, the overarching principle when it comes to diplomatic protection is that it is only the state of citizenship that is entitled to provide diplomatic protection to individuals. Namely, other states are not required to accept protection of individuals or, as it were, proceedings on behalf of an individual unless the states making them is that person's state of nationality. But the development through at least the draft articles on diplomatic protection of the International Law Commission suggests, or these draft articles suggest, that there should be made a refugee exception to this general rule, or to this general notion of nationality of claims. And that rule will be that a state may be able to exercise diplomatic protection in respect of a person who is recognized as a refugee by that state. And I suggest, as the International Law Commission commentary suggests, that this is both an exercise in progressive development of the law, but it's an exercise of that form because of the recognition, on the one hand, of the fact that the citizen retains a link to her state of origin after they've left it. That relations is normally one that is retained. And if it is severed, there needs to be something that comes in place of that connection. And that's something in relation to refugees is the protection, as it were, in loco civitatis. So in sort of a civic capacity of the state of asylum. And that takes me to voting. Because what I suggest is that here the political predicament is the clearest. And that is that refugees do not have access to electoral participation of their state of origin. And that is either through the form of out-of-country voting, if otherwise citizens of the state are able to vote from abroad, like citizens of this country if they are outside the UK for less than 15 years, citizens of Germany for whichever period of time they remain outside Germany, and various other states, over 120 states of the world allow some form of out-of-country voting. But most crucially, they obviously cannot return to their country of origin and participate in elections in that state. And that is because that form of participation would be, and I think fairly justifiably, considered by a state of asylum as tying or mending the political ties that that person enjoyed with their state of origin. And in an article that's actually coming out in a book also in the series through the Refugee Law Initiative on exploring the boundaries of refugee protection, what I suggest there is that the very interesting contrast here is between refugees under the 51 Convention and conflict-formed migrants who return to their state of origin after a conflict has ended and there has been a political transformation, like we've seen in the Balkans, and like we saw to some extent in South Sudan as well. And what I suggest is that in these sorts of situations, the political participation in the elections of the state of origin actually becomes a form of the political transformation of that polity as a whole. It's reintegrating the person into that polity. And that can only happen when there is that form of fundamental change in circumstances, which by definition does not exist when we're thinking about recognized refugees, as long as the status is retained, that is, as long as the circumstances that justify its retention are still in place. And again, the contrast here to the Migrant Workers Convention, I think, is very revealing. Because whilst the Migrant Working Convention, generally speaking, guarantees migrant workers' rights in their state of residence, their state of employment, the only two exceptions to this are the notion of diplomatic protection, which I mentioned a few minutes ago, and the question of elections. So on elections, as you will note, the language is that migrant workers and members of their families shall have the right to participate in public affairs of their state of origin and to vote and be elected in elections of that state. And as I said, this is a fairly recent international document, and I think that's significant. So, what is the meaning of recognition? As I've said, the meaning of recognition is a recognition by a state of asylum that the individual suffers from political predicament, and so there needs to be, I suggest, political remedies that follow from this. The indeterminate length of stay, I suggest, plays in favor of this form of integration. And that is because the state of asylum, save for naturalization, doesn't know how long the person is going to remain. It is, once that person has been recognized as a refugee, it is in that state's interest for that person to be as well integrated as possible. And I think there is a strong argument or a strong correlation to suggest that integration would be strongly enhanced by that notion that a person feels that they're a part of the political community. I'm not going to have time at the lecture itself, but I'm happy to address any questions to talk about the various rationales that stand behind the significance of the right to vote more broadly. Right? This is a question that I address in the wider work. The notion that voting has both intrinsic and instrumental value. The intrinsic value relates to a notion of dignity, of equal worth, and acknowledgement of membership by one's peers, and a notion of autonomy and self-expression, and of course the instrumental elements that relate to protecting one's interests through that process. So I'm gonna leave that at that very cursory level, but I'm happy to return to it. But the broader suggestion is that the right way to read Article 34 in that respect is that while states are not required to naturalize, they are required as far as possible to facilitate assimilation and naturalization. Assimilation has been read to mean, both in the travaux préparatoires of the Convention and in various articles since then, has been read to mean integration rather than loss of that person's identity. And I suggest that integration is greatly facilitated by participation. And I think, again, a recent document that has extended the kind of benefits the EU offers long-term residents, that is third country nationals who are long-term residents in the EU, which originally excluded refugees. Now, since 2011, since the recast includes refugees and excludes asylum seekers, so draws the distinction on that line, on the line of recognition of status. I think is a very important distinction to be drawn. And I want to finish by looking at why all of this fits into what I call the voting citizenship nexus. And here the argument I make, and it goes back again to that initial point about this not being a binary. The point I make is, I think some of the arguments that suggest that voting is normally restricted in national elections at least to full members of the political community have some weight, have some merit. I suggest they have less merit when it comes to refugees, and I suggest conversely that the arguments that are also quite strong, that militate for the disaggregation of voting for citizenship, for attaching citizenship to residence rather than, that attaches voting to residence rather than citizenship, that these arguments are manifestly stronger when it comes to recognize refugees than when it comes to other forms of non-citizen residence. And what I mean is the following. The inseparability arguments are usually of the following four forms. The first is the idea that citizens enjoy a form of social cohesion, and the political process is part of what facilitates that cohesion. Now I suggest that again, as opposed to migrants who come especially on a fixed-term visa, when you've got somebody who you admit has suffered a political predicament, and you recognize that political predicament as the ground for admitting that person into your political community, then the notion that that person's full recognition as a member would somehow limit the social cohesion of society, I think carries less weight. I think equally the idea that persons who are in the state and who are not its citizens will enjoy less loyalty to that state because they will enjoy a loyalty to another state carries less weight. Now this used to be the main argument against dual citizenship or nationality. The idea is that somebody enjoys allegiance to another state. Now as that argument weakens in relation to citizenship, I think it weakens accordingly also in relation to voting. But even if it retains some weight in relation to citizenship and voting in normal circumstances, it is rather preposterous, one might say, to say that if somebody has fled a state because they suffer or they have a well-founded fear of persecution in that state, that they will somehow have a conflict of interest between the interests of that state as it's manifested through its current regime and the interests of the state in which they currently reside. And so that loyalty argument, I think, is not particularly convincing. And similarly, I think, is the case about the evaluation of citizenship. The idea that if you extend voting rights to persons, then they will no longer want to seek citizenship. Now that may be a fairly reasonably strong argument when it comes to individuals who are voluntary migrants, especially from countries with which they enjoy good relations, right? Because these are countries to which they can return at any point. These may be very developed countries and strong countries. And so it may very well be, not suggesting it's a very strong argument in of itself, but it may very well be convincing to say that if you extend all of the citizenship-dependent rights to voluntary migrants, then voluntary migrants will not rush to become citizens. I think when it comes to refugees who have no such form of political relation or realizable right to return to their state of origin, that argument doesn't hold water, at least not to the same degree. The argument that I think is a strong argument, even in relation to refugees, is the stakeholder principle, developed by Rainer Warburg, a person I've written with as well, actually in relation to the last Scottish referendum and to participation in independence referendums more broadly. And that's the argument that the reason why we attach voting to citizenship and why we won't want to sever that tie generally if a person is temporarily outside their state of citizenship, that is if they live abroad, is precisely because of that idea of the permanent link between a person and her state. Precisely because that person retains at any point in time a right to return to that state, that possibility creates a degree of stakeholding in the well-being of that state and in the well-being of that community. And that is a strong argument. And that is clearly a situation that is weaker for refugees whose term of presence is indeterminate. The answers to this contention, I think, are twofold. The first answer is, it is true that the period of residence of refugees is not permanent, but it is also not fixed. In other words, it's not a case in which a person has arrived in a state and know what is their end date. That their commitment to that state is a limited and fixed one. It is a period which neither of the sides know how long it's going to last, and there is a degree to which the refugee, having no realizable right to return anywhere else, actually has an interest in the well-being of the state that has extended them asylum. But I think the other argument is that if this is the reason why states don't want to extend voting rights to citizens, then the natural step for them to follow is to offer them citizenship, which would then allow that form of permanent membership. If they're unwilling to do so because they think refugee status at some point may cease, and if they leave refugees in that status of legal limbo, then I think it's disingenuous then to deny on that basis political participation to refugees. So these are the arguments on the inseparabilities that I suggest are slightly weaker or significantly weaker with refugees. And the reason I suggest the arguments on disaggregation of voting for citizenship are stronger in relation to refugees are the following. I think the argument on unfairness and burden sharing is probably equally plausible to refugees and other migrants. That's the argument that generally suggests if you're a resident, you are a contributor to society, you may be a taxpayer, you may send your children to schools, you may be involved in various community activities. There's nothing in that form that distinguishes you from a citizen. I think that argument holds for refugees as it does for other groups. I don't think it's necessarily stronger. I think the other two arguments are manifestly stronger for refugees. The first argument is that idea of the lack of exit option and as a consequence of that lack of exit option, the dependence. And the idea here is as follows. The more likely it is a person to be able to leave if they're unhappy, to be able to leave if they're mistreated, to be able to leave if they're not being taken care of properly, the less they need the reliance on participation in that particular state, the less they are dependent on that state. And that becomes even stronger if you combine the idea of, say, a voluntary migrant with a state of origin of that voluntary migrant, which has considerable power and influence over the state of employment. So take, for example, somebody from the United States who works voluntarily in the United Kingdom. Even if they don't enjoy a right to vote here, the situation in which a US national would be mistreated by the UK and the US would not respond in kind, and that person would not be able, if they're really fundamentally now frustrated, to return to the US is a very weak possibility. If you contrast it to that Eritrean citizen who ends up being recognized as a refugee and living in the UK and being mistreated here and having no realizable right to return to Eritrea and no recourse to the protection of Eritrea abroad, you see where the gap between dependency and exit option lie. And very much related to this is the notion of subjection to unaccountable power. It's the idea that, generally speaking, if you are living in a territory and you're subject to the laws passed by that legislator, and you have no ability to influence these laws and no ability to hold to account instances in which your rights are being violated, then you are in a worse off situation. Now, it is the case that refugees, like other non-citizens, have recourse to the legal system. And that is something that is actually one of the fundamental rights under the Refugee Convention as well, the ability to access, to have recourse to justice. And that means that violations of their rights as they are enforced by law and are regulated by law may have some degree of recourse through the general channels. But what they're unable to do, almost by definition, is to affect policies of that state in a way that also takes into account their interests and needs. And conversely, it's very clear that if you've got a situation in which refugees live in a particular locality, and there are other people living in the same locality who are citizens, the politicians, by definition, will want to have recourse only to their prospective voters and not to those who are not the voters. And so refugees are in that situation in which, on the one hand, they have no realizable right to return to their state of origin, they have no recourse to its protection, and they're subject to unaccountable power in the state of asylum. And I suggest that all of these factors, combined with that indeterminate nature of their status, which makes them particularly politically vulnerable, necessitate that states would consider, at least, extending voting rights to refugees on all levels. And I welcome any questions on any of this. Thank you.